Hello, and thank you for joining us this afternoon. My name is Ryan Gardner, and on behalf of Fiduciary Investment Advisors and Morgan Lewis, it is my pleasure to kick off today's webinar. Today's webinar, the DOL's Fiduciary Rule, what is it and how will it affect your plan, is scheduled to last approximately 1 hour, followed by the opportunity to pose questions to our speakers. Questions can be submitted via the question box on your control panel at any time during our webinar. For attorneys seeking CLE credit for attending this webinar, there will be additional information towards the end of today's program. First, I would like to introduce our two firms. Fiduciary Investment Advisors is an institutional retirement plan and investment consultant with offices in Windsor, Connecticut, Boston, Massachusetts, and Kennebunk, Maine. We are an independent firm that offers customized advice to a broad array of institutional clients, including retirement plan sponsors and endowments and foundations. In total, we advise on over $45 billion in fiduciary assets. FIA was recently ranked as one of the top 50 institutional consulting firms by pension and investments as measured by assets under advisement. Morgan Lewis is one of the largest U.S. law firms with more than 2,000 legal professionals working across 28 offices in North America, Europe, Asia, and the Middle East, with approximately 70 lawyers and other benefits professionals. Morgan Lewis has one of the largest and deepest employee benefits and executive compensation practices in the country, assisting clients with all aspects of their benefit offerings, including qualified and non-qualified retirement plans, health and welfare plans, and executive and equity compensation plans. It is now my pleasure to introduce Morgan Lewis Employee Benefits and Executive Compensation Partners, Amy Kelly and Bob Abramowitz, who will lead us in this afternoon's discussion. Bob is a partner with Morgan Lewis and counsels clients on employee benefits matters, including fiduciary requirements under ERISA, qualified pension and profit sharing plans, and executive compensation issues. Amy is a partner with Morgan Lewis who provides strategic day-to-day guidance to public, private, tax-exempt, and governmental entities on employee benefits matters, including design, governance, and compliance on a variety of plan types. So with that, let's dive into our presentation for the day. And we'll start with the first question to Amy. But before we get into the new fiduciary rules and why they're important, Amy, I thought you could give the listeners a little bit of context for how the rules are applied today.
Sure, thanks, Ryan. So to understand the new rules, I do think it helps to understand the old rules. Under Section 321 of ERISA and 4975E3 of the Internal Revenue Code, a person is a fiduciary with respect to a plan if the person exercises discretionary authority or control with respect to the management of the plan, or any kind of control with respect to the management or disposition of plan assets. If the person renders investment advice for a fee, and hold on to that term, investment advice, for a fee or other compensation, direct or indirect, or has any discretionary authority or responsibility in the administration of a plan. For purposes of that existing rule, in 1975, the Department of Labor issued a 5-part test narrowing the scope of fiduciary investment advice. Under the test, an investment advisor is a fiduciary under ERISA if each of the following 5 elements is satisfied. The individual makes recommendations on investing in securities or other property on a regular basis, pursuant to a mutual understanding that the advice will serve as the primary basis for investment, will be individualized for the particular and will be individualized for the particular needs of the plan. So for purposes of that foregoing test, hold on to the word recommendations because that will come up again later. Under the new rules expand the definition of investment advice fiduciary and amend several prohibited transaction class exemptions. The new rules have a profound impact on how services are provided to ERISA plans and IRAs, how investment products and services are sold to ERISA plans, IRAs, and intermediaries that become fiduciaries under the new rule. And they will also affect the disclosures provided to plan participants, plan fiduciaries, and individual retirement accounts. The primary reasons that the Department of Labor issued the new regulations was to address perceived inherent conflicts of interest of financial services providers in providing retirement investment advice to retirement plan participants and individual IRA owners. Specifically, the DOL didn't think that there was any obligation to put the participants' interests first. The next reason, or the next sort of identified issue from the DOL standpoint, is that there's been a dramatic shift in the retirement savings system from defined benefit plans to defined contribution plans in the last several years, and workers are largely responsible for managing their own assets in participant-directed plans, and there are significant assets moving from ERISA plans to individual retirement accounts via rollovers. And then lastly, there's been an expansion in the variety and complexity of the financial products. And so for all of these reasons, I think the DOL's position is that there needed to be kind of more regulation around how investment advice is being provided. I think the DOL also perceived some regulatory gaps with respect to financial advisor activities, and that those existing rules didn't cover activities involving investment advice regarding retirement savings. So sort of big picture, why these new rules are important.
Great. So potentially a lot to think about as a plan sponsor, and I know as we go through, Amy and Bob will continue to give us more specifics. Maybe as a follow-up to the first question, Amy, if you could tell us if there are any employers or plans not covered under the new rules.
Sure. So under the new rules, governmental plans, most church plans, and non-qualified plans are not covered by the new rules. Those are sort of pretty broad categories. That said, all ERISA plans are covered by the new rules, as are individual retirement accounts, which is new. That was sort of a big gap before, and they are now picked up by these new rules, which has been the subject of some much consternation.
Right. And I know we'll get into in just a couple of slides from Bob some of the considerations, but Amy, if you could help us with understanding when these new rules will become effective.
Sure. So the Department of Labor released the final rule on April 6th of this year. The effective date is June 7th, 2016. Final rules become effective 60 days after publication in the Federal Register. There's a transition period until April 10th, 2017, and during the period between now and April 10, 2017, the revised definition of fiduciary investment advice and the new and amended prohibited transaction exemptions are not applicable until April 10th, 2017. And then Bob will talk about the best interest contract exemption, but the limited conditions of the best interest contract exemption, the principal trading exemptions, apply during the transition period. And then effective 1/1/18, the transition period ends and the full conditions of the exemptions apply.
Okay, so let's take a step back for just a minute and maybe hit some of the basics. A question that we hear regularly from plan sponsors and fiduciaries, and that is, who is a plan fiduciary under these new rules?
So under the new rules, the definition of investment advice fiduciary is a person who provides certain types of recommendations to a plan. So recall that I noted earlier that word recommendation. And under the old rule, the 5-part test I talked about what was fiduciary investment advice, the first prong was making recommendations on investing. So the new rule retains that recommendations concept. And so it's a person who provides certain types of recommendations to a plan fiduciary, plan participant or beneficiary, IRA or IRA owner, for a fee or other direct or indirect compensation, and then meets any one of the following criteria. The person represents or acknowledges that he or she is acting as a fiduciary within the meaning of ERISA or the code. The advice is rendered pursuant to a written or verbal agreement, arrangement, or understanding that is based on the particular investment needs of the advice recipient, or the person directs the advice to a specific recipient on the advisability of a particular investment or management decision about plan or IRA assets. So it begs the question, what is a recommendation? And the requirement that an investment advice fiduciary make a recommendation is a new requirement under the final rules and is key to the determination of fiduciary status. What constitutes a recommendation is intended to be based on an objective standard. So there's 4 kind of components to this. The recommendation must reasonably be viewed as a suggestion that the recipient take or not take a particular course of action. The recommendation has to be the more individually tailored the recommendation is, the more likely it will be considered a recommendation. And we'll talk about that a little bit in a minute as it relates to sort of what's education versus advice or a recommendation. Individual actions that may not constitute a recommendation by themselves can be a recommendation when aggregated with other actions. And importantly, this last prong, recommendations can be made by a person or computer software program. Recommendations include recommendations to buy, sell, or hold securities or assets, recommendations related to the management assets like investment policies and strategies, portfolio composition, selection of investment advice, selection of investment account arrangements, recommendations related to the investment of assets after they're rolled over, which is another important component of the new rule, transferred or distributed from a plan to an IRA. And then there are a category of items that are not recommendations. So marketing by independent platform providers, providing investment option platform or selection and monitoring assistance related to the platform itself, certain selection and monitoring assistance, and then general communications that a reasonable person would not view as an investment recommendation, such as investment education, which we will talk about a bit more.
And maybe that's a good segue, Amy. One of the common questions that we're seeing in the marketplace is how this new rule may impact the education services provided to participants and plans.
So that's a great question. Under the final rule, the definition of fiduciary investment advice is not meant to include general investment education and educational materials. There's sort of 4 categories of educational information under the new final rule that do not involve fiduciary recommendations. The first is plan information, including information that describes investments or plan alternatives without specifically recommending particular investments or strategies. General financial, investment, or retirement information, asset allocation models, and they may include reference to specific products for ERISA plans only, not IRAs, and then interactive investment materials, questionnaires, worksheets, or software. It does not matter who provides the information, the frequency with which the information is provided, the form of the information, or whether the information is provided in combination with other types of information, as long as it's not with certain investment-related recommendations. I think the rule significantly changes when educational materials can identify specific investment alternatives in asset allocation models and interactive investment materials, because under prior guidance, you could use models that identified specific investment alternatives, including the specific investment alternatives available under the plan, so long as The material stated that other investment alternatives with similar risk and return characteristics may be made available under the plan, and then identified where information on the investment alternatives can be obtained. But under the new rule, you can't provide information where you're identifying certain funds on the plan's platform. So all designated investment alternatives under the plan with similar risk and return characteristics have to be identified in the materials. And the materials also must include a statement on where additional information can be obtained. And the investment alternative must be a designated investment alternative subject to oversight by an independent plan fiduciary. This represents a departure from prior DOL interpretive guidance under Interpretive Bulletin 96-1.
So potentially a number of areas for plan sponsors to look at and consider once the new rules take effect. And Amy, you mentioned advice as well. We're going to come to that in just a minute. But before we do, Bob, let's switch gears for a second and touch on something that Amy mentioned earlier. And the language that exists in the new rule that may allow certain advisors and other vendors to continue with current practices, and that is, can you tell us more about the best interest contract exemption?
Thank you, Ryan. I'd be glad to. The best interest contract exemption, or the BIC exemption, or BICE, is at the heart of the new regulations. It's designed to protect participants and certain plan sponsors from conflicts of interest of financial advisors. The exemption is limited to financial advisors who receive compensation based on advice given and who provide advice to retail customers. And for this purpose, retail customers include participants in defined contribution plans such as 401k and 403b plans on how to invest their account. It involves IRA customers, and it also involves advice to smaller plans where the fiduciaries are not considered to be sophisticated. Generally, the breakpoint is 50 million in assets. So the exemption is crucial for financial advisory firms and is at the heart of the reaction of those firms to the rules. It is requiring them, in some cases, to transform the way they provide business and charge for their business. The BIC exemption is not available to transactions with sophisticated counterparties, that is the large plan marketplace with respect to plan sponsors. So to receive a fee for services provided to retail customers, a financial advisor needs an exemption or an exception, and the BIC exemption in many cases will be the only possible one that's available. Now, the BIC exemption is complicated. There are lots of rules and exceptions, and I'm just going to focus on those aspects of the exemption that are of most interest to plan sponsors. So one of the key requirements of a BIC exemption is a written acknowledgement of fiduciary status by the financial advisor. A second requirement is adherence to impartial conduct standards, and I'll have more on that in a minute. A third requirement is a number of warranties that need to be made by the financial advisor. The financial advisor has to warrant that it will adhere to the impartial conduct standards, that it has identified and documented its material conflicts of interest and has taken appropriate measures to deal with them. And it has to warrant that there are no quotas, bonuses, contests, or special awards or other incentives that are in place that would encourage advisors to make recommendations not in the best interest of retirement investors. So this is really adding teeth to the fiduciary rules. The impartial conduct standards include a list of things, and I'll mention just a few of them. One of them is a promise to provide investment advice that is in the best interest of the retirement plan investor. It is a requirement that all compensation will be reasonable within the meaning of ERISA Section 408(b)(2). And then the financial advisor conduct is that any statements it makes regarding investments, fees, and conflicts of interest are not misleading. There are some prohibited terms in the BIC exemption, so that the arrangements with the retail investor can include exculpatory provisions that basically take out the risk component if the financial advisor fails to meet applicable requirements. The agreement with the retail investor can't require a waiver of class actions. And there are also a requirement that it can't limit recoveries in certain respects, such as, well, you know, you can only recover liquidated damages of $1,000 no matter what we do. That sort of provision is prohibited. So I think from that we can observe that the Department of Labor is anticipating that there will be private rights of action that will serve as a means of enforcing these rules, which may mean a lot more litigation down the road. In terms of required disclosures to participants, another element of the BIC exemption, the financial advisor needs to have a public website with many details, including how the individual advisors are compensated and the incentive arrangements that are in place. The financial advisor needs to provide notice to the Department of Labor that the financial advisor is relying on the BIC exemption, and the financial advisor needs to keep pertinent records for at least 6 years. Now, as hard as these rules may be, they are a liberalization of some of the intermediate rules that had been proposed by the Department of Labor. The BIC exemption does allow for proprietary products. There was a concern that financial advisors would be essentially unable to provide proprietary products. It allows for commissions. That was another concern as to whether commissioned products would be flat out prohibited. But it will require virtually all financial service firms to review how they and their advisors deliver services to plans, participants, IRA owners, and other retail investors. And it's likely to require that financial service firms review how they compensate their individual advisors.
So, Bob, I think one of the things that you mentioned early in that statement was the reaction from the industry, and there have been at least 2 or 3 lawsuits against the Department of Labor, and specifically the marketplace's thought on how advice may be impacted by the new rules, specifically advice for folks nearing or in retirement around distributions and forms of distributions. Can you tell us a little bit more about how that area may be impacted as well?
Sure. The rules that Amy described that are currently in place, and which the new DOL rules will change, generally don't include advices to distributions as fiduciary advice. And that advice is not subject to fiduciary rules currently. But as Amy described, if we have a covered advisor and a covered recommendation under the new rules, there will be a situation where advice on distributions is fiduciary investment advice. The new rules include a covered advisor as anyone who's directing advice to a specific advice recipient regarding the advisability of a particular investment or arrangement decision, which is very broad. And a covered recommendation includes a recommendation as to rollovers, including distribution. It extends to how property should be invested in an IRA and to management of investment property. So advice on whether to leave funds in an existing plan or to take a rollover into an IRA, much less as to how to invest the IRA, will now be, in all likelihood, fiduciary investment advice.
So Ryan, sorry, Bob.
Go ahead.
Just to pipe in there for a second. So from a plan sponsor's perspective, you know, as we're kind of watching this all unfold, I think it would be important for plan sponsors to consider kind of what their rollover materials look like, to engage with their vendors and service providers to understand, you know, how they'll be adjusting their documentation and communications vis-a-vis participants to address these sorts of issues.
That's exactly right. That we expect plan sponsors to take a more active role. And one of the implications may be fewer rollovers out of a plan. Some plan sponsors may view that as a good thing. With more assets in the plan, there are more assets under management, and it may reduce average costs. But some plan sponsors may view it as a bad thing because it's another participant to keep track of and to deal with. But that's one of the implications. There's some important exceptions to the who's a fiduciary, though, in this context that I wanted to mention. These exceptions are intended to allow for smooth working of internal administration of the plan and to allow for routine benefit communications with participants. So one exception is if an employee of a plan sponsor provides investment advice or similar advice to a plan sponsor or a plan fiduciary. That employee won't be a fiduciary with respect to the plan if they are not otherwise a fiduciary, and they don't receive a fee or other compensation for providing the advice. So it's often common for somebody in the, say, Treasury Department to provide input to the internal fiduciaries on fund performance or fund selection. So there is an exception that's available there. Another exception is available for people interacting with participants so long as their job function does not involve investment advice and recommendations. They are not licensed or registered under federal or state securities laws, and they receive no fee or other compensation apart from normal compensation for work performed. So if somebody in HR gets an inquiry about, well, should I take a distribution or should I leave my money in the plan, and the response in HR maybe strays over the line, as long as the individual providing that advice meets those requirements, there shouldn't be a problem. But in other situations, though, where employees, part of their job function is to provide advice and recommendations, this exemption or exception would not be available.
So in thinking about Amy's comments around potentially for plan sponsors to review rollover materials and other participant communications, and Bob, your thoughts on plan sponsors potentially having to take on a more active role, are there tips that plan sponsors should be thinking about between now and next April when the rule goes into effect?
Yes, absolutely. While the burden of the new fiduciary rules will fall primarily on financial services firms, there are still a number of concerns for plan sponsors. As we just discussed, plan sponsors will want to make sure that their employees are not inadvertently fiduciaries when you don't want them to be fiduciaries. And that may require checking how they're paid, what their job description is, what their interactions are with participants. If the plan sponsors' employees are not providing advice as to distributions and so forth, the plan sponsor will want to carefully consider, well, who is and what sort of oversight do we have in place? A second important area are all the service agreements that a plan sponsor has with its existing advisors and service providers. We recommend that plan sponsors inventory those relationships and keep track of how those advisors and service providers are going to deal with the new fiduciary rules. In general, these firms will have one of two choices. One is to say, okay, we are a fiduciary, or we're willing to be a fiduciary, and we'll step up to the plate on those rules. Or they will want to make sure that they are not a fiduciary, and will take steps to avoid being a fiduciary in their documentation. There's not a right or a wrong approach here, but the plan sponsor will want to keep track of what the approach is and whether that approach is consistent with the plan sponsor's expectations. Where a service provider maybe is not currently a fiduciary but becomes a fiduciary, we would expect not only would there be new documentation of the arrangement, but there might be some change in fees, because now the service provider is taking on a higher risk as a fiduciary, and one of its income streams, i.e. IRA rollovers, may no longer be available. I think many service providers look to their service arrangement as a means of gaining access to participant IRA accounts when they left the plan, and the new fiduciary rules will have a direct impact on when that occurs and how often that occurs, and that whole business model. Another area is to review investment education provided to participants, including materials provided by third parties, particularly if there are asset allocation models. And here I'm going to read something from the preamble that I think is directed squarely at plan sponsors. Quote, in this connection, it is important to emphasize that a responsible plan fiduciary would also have, as part of the ERISA obligation to monitor plan service providers, an obligation to evaluate and periodically monitor the asset allocation model and interactive materials being made available to the plan participants and beneficiaries as part of any education program. That evaluation should include an evaluation of whether the models and materials are in fact unbiased and not designed to influence investment decisions towards particular investments that result in higher fees or compensation being paid to parties that provide investments or investment-related services to the plan. So the Department of Labor clearly contemplates that plan sponsors, or fiduciaries allied with the plan sponsor or designated by the plan sponsor, need to review investment education materials. Another area that plan sponsors will have concerns about is distribution counseling. Is it being handled internally, or is it being handled by a third party? In either case, are these folks fiduciaries? Plan sponsors may want to look at the scripts that the call center folks use when they handle calls. So that's another area of oversight. If a plan sponsor is considering a vendor change this year, even though the rules aren't currently in effect, the plan sponsor should take into account the new rules and make sure that that the new service provider or advisor is going to do what the plan sponsor wants it to do in connection with the fiduciary rules. Otherwise, you'll have to do the whole exercise over again next year. There are a couple of areas of particular concern to large plan sponsors. Some large plan sponsors have counterparties. They invest with private equity or hedge funds, and those parties will generally need to rely on what's called the seller's exception under the new fiduciary rules. So there is an exception for, say, private investment firms to market and give advice to large plans and large plan fiduciaries, but generally speaking, they'll need to qualify for the seller's exception. So the plan sponsor will want to make sure that they get updated materials, that they get required disclosures, and that the seller's exception is met in those instances. More generally, plan sponsors will want to verify that their plan investment managers can continue to rely on needed prohibited transaction exemptions that are amended by the final rule. In addition to the BIC exemption, the fiduciary rules amended many of the outstanding exemptions, and so both parties, the plan sponsor and the counterparty, need to make sure that an exemption is available to avoid a prohibited transaction. Just two other things to keep in mind for plan sponsors. One is to be prepared to respond to participant inquiries. The new fiduciary rules are getting a lot of press, and we think plan sponsors would be well advised to at least have a response if participants come and say, what does all this mean, or what are you doing about it, or what should I be doing about it? And some plan sponsors may decide even to be more proactive and to go to the participants and explain what they should be looking for from their financial advisors in connection with distribution advice, rollover advice, and the like. And finally, we recommend that plan sponsors determine a timetable for compliance. Right now, I think the large financial services firms are scrambling to get in place their business plan for meeting the new rules. So, it may be a couple of months before they're ready to roll out their compliance plans, but certainly by the fall or early winter, plan sponsors should be in a position to expect to receive some thoughts from their advisors and service providers about how those organizations will meet the new requirements.
Bob, let's continue to focus on the plan sponsor for just a minute, maybe some of the nuance of the new rule, and specifically for plan sponsors in the financial services industry, what the expected impact may be for those groups.
Well, these are challenging times for firms in the financial services industry. I think I already mentioned that they may need to revise their compensation arrangements for advisors, or maybe even their business model, and that already is, very disruptive. And it means that there's a lot going on in human resources. So, but financial services firms also sponsor their own plans for their own employees that may create some special challenges. This, I think, is particularly the case if the plan offers proprietary products. I think plan sponsors will want to review the continued use of proprietary products under the new rules. While the new rules clearly allow the use of proprietary products, they certainly, the regulations are long and detailed, and is, I think, a reason for financial services companies to take to revisit and take another look at this. I think they'll want to review their investment education of participants, including the role of employees and whether the employees may be deemed to be fiduciaries. And then another area is the distribution advice, particularly on rollovers, on distribution. I think many financial services firms would like to promote or would, their own IRA products to their own employees, in part to keep the relationship alive, and in part as a revenue stream. But these new fiduciary rules clearly are intended to impact the advice given to plan participants. So that is an area that I think financial services firms will need to examine. There are also some older guidance provided by the Department of Labor as to when an IRA might be considered an employer-sponsored IRA, which may be relevant to certain financial services firms. I want to mention that more guidance is expected in a number of areas, sometimes referred to as sub-regulatory guidance in the form of questions and answers. I think we've seen a lot of that with the Affordable Care Act. I think the governmental agencies have come to like that approach. And I think this is one of the areas where I think some additional guidance would be welcome, because there are a lot of questions raised by how these new rules will affect financial services firms and the plans they offer to their own employees.
So Bob, so far we've talked a lot about plans covered under ERISA and the impacts there. Switching gears again for just a second, what should sponsors of state and local defined benefit and defined contribution plans be thinking about in the context of this new rule?
Well, that's a good question, and I think my answer will also relate in part to church plans that are otherwise not subject to the new rule. These plans are not directly covered by ERISA, but I think the ERISA and the regulations that come out of ERISA often informs what many view as best practice. In addition, some state and local government plans by contract require service providers or advisors to act as though ERISA applies. So, so by contract, these rules may end up being applicable. But even if that's not the case, I think it is a fair question for the fiduciaries of a state and local governmental plan to ask, to what extent are these rules desirable? Is this something we would want to request our service providers or advisors to provide? Would that have an impact on fees? Is there some sort of cost-benefit analysis to be undertaken there? And then there's been some publicity about some new state programs that are designed to make it easier for small employers to adopt a plan for employees. These are usually structured either as using individual retirement accounts or ERISA plans. The new fiduciary rules would be directly applicable to those plans, even though they are offered through the medium of a state government. And then to the extent a participant in a governmental plan rolls over into an IRA, once the money is in an IRA, the new fiduciary rules will apply. There is no distinction in the fiduciary rules on the source of funding of the IRA. So it's possible state and local government employers will want to consider go outreach to their participants to talk about whether those participants should try to make sure that their advisors meet the new BIC exemption on counseling about distributions in connection with any possible rollover to an IRA.
And maybe, Bob, one last follow-up question to that in terms of best practices for governmental plans in states with many ERISA prohibited transactions.
Mm-hmm. Well, as you note, some state and local retirement systems are governed by state laws that seek to apply ERISA-like fiduciary requirements, especially as they relate to prohibited transactions. In addition, state and local government plans are subject to Section 503 of the Internal Revenue Code, which includes some specific rules. So we think that a state and local government employer should follow the same steps as a private sector plan would to mitigate prohibited transaction exposure. And the extent of that exposure and the what prohibited transaction rules apply may very much depend on the particular state that's under discussion. But you start by determining fiduciary duties, what are prohibited transactions, what potential exemptions apply to the governmental plan, and the sources of those include state law, Section 503 of the Internal Revenue Code. There may be codes of conduct for system plans, but in any event, inventory, who's a fiduciary, what rules apply, and then make sure that the fiduciaries are educated as to those rules and that the counterparties are educated so that they can meet prohibited transaction exemptions. That the paperwork or the agreements with counterparties will help cover accountability, who's accountable for making sure that the any exemptions to prohibited transactions are met. As with private plans, we think it's important that state and local governmental plans document and implement a prudent process. ERISA puts great emphasis on process, and I think state law, state fiduciary law would likewise look to process so they're not Monday morning quarterbacking as to investment results, but it is easier to determine if a process was prudent, if say guidelines are adopted and the organization doesn't follow its own guidelines, that is may be viewed as evidence of imprudence. And another thing that state and local governments can consider are insurance, fiduciary insurance, and indemnifications as appropriate to make sure that individuals are protected if they're acting in good faith.
Great. Well, Bob, thank you, and Amy, thank you for all your comments and thoughts about how the new rule will have an impact on the industry. Hopefully everybody sees on their screen in front of them the alphanumeric code for the CLE credits, and maybe while folks are jotting that down, and in the interest of keeping to our 60 minutes, we did have a number of questions that came in. I think between Bob, Amy, and myself, we'll get together and make sure we respond to each one of those after the session. But maybe to close us out, there was a question that came in early on about the impact of some of the recent litigation by 2 or 3 associations against the Department of Labor in an effort to try and either slow down or stop the new fiduciary rules. So maybe Bob and or Amy, in just a couple minutes, can we get your thoughts on how successful you think these attempts may be, or do we believe the DOL is going to push ahead with the rule as it's been proposed?
Well, this is Bob. Amy may want to supplement, but I think that it may be an uphill struggle, but even if it's successful, the timing may be such that by the time we get a decision, it may be a long time down the road. So that I think plan sponsors should be prepared to act as though the rules will go into effect on the scheduled implementation dates. That's my personal view.
I tend to agree with that. I think, Ryan, to answer your question, I think that DOL will push full steam ahead. The litigation will play itself out how it plays itself out, but in the meantime, there's sort of no suggestion that that will have any impact on the effective date.
Okay, great. Well, thank you both again, and thank you for everyone who dialed in and joined us this afternoon. As I said, between myself, Bob, and Amy, we'll do our best to follow up and answer each one of the questions that came in. And thank you all once again for joining us this afternoon.